in April of 2020.
Did he disappear?
I think so, Your Honor.
Let me get him back on, Judge. He's next door to me. Hold on, please.
Okay.
I thought that was my computer.
Yeah.
You can never tell nowadays.
Sorry about that, Your Honor. Had a technical difficulty.
Okay.
So back in April of 2020, plaintiff filed this lawsuit to enforce the settlement agreement between the parties. And then 2 months later, plaintiff filed a motion for partial summary judgment as to our affirmative claims, asking for two things. One, that this court enter a declaration that defendant had breached the party settlement agreement by violating a non-disparagement provision, and two, permanent injunction that would stop defendant from further disparaging plaintiff. On August 20th, the court granted plaintiff's motion, finding that defendant had breached the settlement agreement by disparaging plaintiff and enjoining defendant from doing that further. At that time, plaintiff sought $33,000 in its fees and $600 in expenses. At that point, defendant then appealed in appeals that lasted for just around 2 years. The Court of Appeals affirmed this court's order. The Texas Supreme Court denied review, and on August 1st of this year, the mandate issued. At that point, defendant then caused a counterclaim to be filed in this lawsuit. The counterclaim stated that that plaintiff had conducted a prior material breach of the settlement agreement, stating two things. One, that there was a breach of the no further litigation provision, and second, that plaintiff itself has violated the non-disparagement provision. So taking those in order, first, as to the no further litigation provision, this court in August of 2020 entertained plaintiff's motion to enforce the settlement agreement. At that time, defendant had already asserted a counterclaim for no further litigation. So the agreement itself contemplates that the parties could bring litigation to enforce the terms of the settlement agreement. Plaintiff has done exactly that by seeking to enforce the terms of the settlement agreement. And we think that the court implicitly ruled in granting our motion for summary judgment way back in August of 2020 that, yes, in fact, plaintiff can enforce the terms of the settlement agreement through litigation, and therefore overruled defendant's counterclaim that that for some reason we wouldn't be able to enforce the settlement agreement, which would effectively nullify the terms of the settlement agreement. Obviously, if we couldn't enforce the terms through relief before this court, my client basically would have no avenue to seek relief, and the words would have no import in the settlement agreement.
Let me ask you a procedural question. I want to make sure I kind of understand the history here. So there was a summary judgment granted. It was appealed. The Court of Appeals affirmed. The Supreme Court denied writ, I guess, and then it looked like 30 days after the final mandate, or over 30 days after the final mandate, there was a counterclaim filed. Is this even, do I even have jurisdiction to hear the counterclaim? Or
Your Honor, I think this is a little different. Actually, there was a defendant filed a TCPA motion to dismiss.
Okay.
And that was the order that was appealed to the fifth district and then the Texas Supreme Court.
Okay.
And so it's that intervening interlocutory appeal of the motion to dismiss that was the appellate delay in this case. There
All right,
was
go
a
ahead.
pending counterclaim at the time that you entered the motion for.
Because according to the clerk's office, this case is closed.
That's correct, Your Honor.
Should it be closed or not?
The court has not ruled as to the counterclaims. It may have implicitly denied those counterclaims, at which point there would be a final judgment. However, there was no ruling during the intervening appellate procedure as to the award of fees to plaintiff. So we think that the affirmative claims have been disposed of, but the amount of our fees are still pending. And so I believe that this court does still have jurisdiction.
So the case should not be closed.
That's correct, Your Honor.
Okay. All right. Anything else?
Well, the defendant also makes an argument as to non-disparagement, that plaintiff breached the non-disparagement provision. As respect to that, there is a single sentence that defendant complains of, which is in a Houston County Court at Law litigation. The defendant's brother sued plaintiff. Plaintiff then caused to be filed a compulsory counterclaim, and in one sentence referenced the defendant and stated that he opened a bank account. While there is that one sentence that references the defendant, we submit to you that that was not disparaging. It was merely a statement of fact. It's recited in both our motion for summary judgment as well as defendant's response. The only statement made with respect to defendant is that he opened a bank account, and that was a necessary compulsory counterclaim made so that we could assert our defenses in that unrelated litigation. So because plaintiff did not malign, criticize, denigrate, or disparage defendant, we don't believe that there is any allegation or any fact that would show that plaintiff has breached the non-disparagement provision, and therefore there's no issue of material fact, and you can grant summary judgment as to that counterclaim. There's also a related issue of a agreed judgment. So the settlement agreement between the parties stated that by June 30, 2020, defendant would pay plaintiff $75,000. Defendant did not do that. Plaintiff has submitted a declaration stating that defendant failed to do that. Defendant does not controvert that he did not pay it. So we're also asking the court to enter a judgment in the amount of that $75,000 because of that breach of the party settlement agreement.
Was that it?
Yes, Your Honor.
Response?
Yeah, thank you, Your Honor. This is David Kassab again on behalf of Amir Skandari. So just by way of background, the court hit it on the head with the jurisdictional question. Yes, this case still needs to be open. Yes, the court does have jurisdiction because there is no final judgment. Mr. Casey filed this lawsuit back in October of 2019, alleging that Mr. Amir Skandari, I'm sorry, that's when the settlement agreement was entered into to settle a host of litigation between Amir and Mr. Kevin Casey. On April 17, 2020 is when Casey filed this lawsuit alleging that Amir Skandari breached the settlement agreement, specifically the non-disparagement clause, by making statements in a lawsuit that Amir filed against a third party. Mr. Casey alleged that lawsuit, the statements in that lawsuit, malign, criticize, or disparage Mr. Casey. They were statements where Amir had recited the facts of the underlying litigation, and some of those facts were that Mr. Casey had engaged in fraud. On June 16, 2020, Casey moved for partial summary judgment on his affirmative claims, which the court granted. The court held that Mr. Miraskandari had breached the settlement agreement by making the statements that he did in that Houston litigation. However, there was a pending counterclaim that was on file at the time. Mr. Miraskandari alleged, because the provision in the settlement agreement was so broad about no further litigation, that Mr. Casey breached the no further litigation provision merely by filing the suit. And Your Honor, that was a counterclaim that was on file from the outset that was never disposed of on summary judgment. After Casey had obtained, or actually while he was obtaining relief on his initial summary judgment motion, Amir Miraskandari filed the TCPA motion, which this court denied, and that's what went up on appeal. The Court of Appeals affirmed. When it came back down, we filed the counterclaim, an amended counterclaim for breach of contract concerning actions that Mr. Casey took in a Houston case that itself breached the non-disparagement provision. And counsel stated that it was one sentence that we are complaining about that's inaccurate. There's about 3 paragraphs in that pleading that we're complaining about, and that is quoted on page 9 of our most recent counterclaim. In essence, Mr. Casey accuses Mr. Miraskandari of assisting his brother in committing fraud on Jinsoon, which is what Kevin Casey's solely owned entity is. And so that was the basis of the amended counterclaim. So Miraskandari asserts 2 counterclaims. 1, filing this lawsuit was a breach of the no further litigation provision. And 2, filing the claim in the Jinsoon litigation was a breach of the settlement agreement. In this motion, Mr. Casey does not move for summary judgment on Miraskandari's counterclaim that Casey breached the settlement agreement by filing this suit. For that reason alone, final judgment is improper. And Casey's filing of the claim against Miraskandari's brother, his name is Aladad, in the Jinsoon litigation, that was a breach of 2 provisions, the no further litigation provision and the non-disparagement provision. In the no further litigation clause, Casey agreed that he will, quote, not solicit, encourage, or assist or cooperate any third party's claim, charge, suit, complaint, action, or proceeding against any entity which Miraskandari is affiliated. He did that by the mere filing of the Jinsoon counterclaim. And that is because the common meaning of entity includes a person, and an affiliate certainly includes a brother. And so by filing that, it was a breach of the no further litigation provision. Also, by accusing Mr. Miraskandari of committing fraud and assisting his brother in, quote, I think he said it was a whole host or a ruse to conceal assets from Jinsoon, he's necessarily criticizing breaching the non-disparagement provision. And the court has to take a look at that provision because it's not just
So
about.
let me do this. Let's break down your counterclaims that they're
Sure.
moving for summary judgment on. So there's multiple aspects of this that you're moving for summary judgment on. So there's the counterclaim for whether or not the filing of the lawsuit against the brother is in violation of the underlying settlement agreement. That's part of it, correct?
Yes.
I'm going to grant summary judgment on that. So what is the rest of your counterclaim?
That filing this lawsuit to begin with was a breach of the no further litigation provision.
I'm going to grant the summary judgment on that. What else is the rest of your counter? So that's 2 parts of your counterclaim. I'm going to grant summary judgment on both of those. What else do we have?
Your Honor, they have not set that motion for summary judgment for hearing.
What?
With regard to the counterclaim that filing this lawsuit was a breach of the breach of the no further litigation provision, that summary judgment motion is not set for hearing today.
Mr. Hopkins, is that correct? Maybe I misunderstood then.
No, Your Honor. We set for hearing today all the counterclaims that they've asserted. So I'm not sure what he's referring to. All the counterclaims the defendant has asserted, we are moving for summary judgment on. We're requesting that the court enter final judgment. And so as part of that, of course, we're looking for summary judgment as to all counterclaims, not just some counterclaims.
Your Honor, you can take a look at the motion. It's very clear. It's only on the Jinsoon litigation.
Let me see. So it says the motion, this motion asks the court to enter a take-nothing judgment on a recently asserted baseless counterclaim filed more than 2 years after this case began. Is that which enter a $75,000 agreed judgment against Miras Skandari regarding his refusal to pay as required by the party settlement agreement and award him his attorney's fees pursuant to chapter 37 and 38. Let's see. Okay, so it's about, I see where you say about Casey, the brother. So where do you discuss this lawsuit? I guess I don't see it.
So, Your Honor, the counterclaim about no further litigation, that dates back all the way to 2020. And we had moved in early August of 2020 for summary judgment as to that counterclaim. And the court granted our motion on the affirmative claims for a declaration and an injunction. And to reach that result, I think that the court would have necessarily had to decide that, yes, plaintiff can enforce the terms of the settlement agreement and therefore overrule the counterclaim.
But it's not addressed in your current summary judgment.
Because it's already addressed in the previous motion for summary judgment. That's correct, Your Honor. If it would help, we're happy to file an amended.
Do I specifically state in the previous summary judgment order that that I had overruled their counterclaim, or that
Correct.
No, Your Honor, I don't think you stated in the summary judgment order that you overruled our counterclaim.
or that I denied the counterclaim, or is it
No.
the counterclaim addressed at all in the previous summary judgment order?
No, Your Honor, because they had only moved for summary judgment on their affirmative claim.
However, the counterclaim was alleged in, I think it was at the time, the second amended answer of defendant. And so to the extent that that was a defense that the defendant was relying on, it's something that the court would have considered. It would have been their live pleading at the time, which was.
But you still have to address it specifically, and I'd have to rule on it specifically. So there's nothing in the previous summary judgment order that discusses that counterclaim.
Not specifically, Your Honor.
All right, then I can't grant summary judgment on it. I am going to grant summary judgment concerning the counterclaim, Miras Skandari's counterclaim regarding the case involving his brother, because that is clearly addressed.
Your Honor, I understand that ruling. Can I just have a ruling on some of the objections I made?
Let's deal with this one at a time.
Okay.
The second thing that was moved on was the agreed $75,000 agreed judgment. And as I understand it, your argument is that you guys withdrew consent because there was a breach.
Correct, Your Honor.
All right. I'm going to grant summary judgment on that. And then attorney's fees.
Yes, Your Honor. We submitted back in August of 2020 our attorney's fees at that time, which were $33,000 approximately. for fees and $650 for expenses. Since that time, there's been a number of appeals, and this litigation has seemed to spawn new counterclaims. And so our new requests for attorney's fees that are right around 120,000 are representative of the 2 years that has since elapsed.
In response to the attorney's fees.
Yeah, Your Honor. Casey sought attorney's fees under two provisions, Chapter 37 and 38 of the Texas Civil Practice and Remedies Code. But Casey only pled attorney's fees pursuant to Chapter 37 and not 38. So we object to a award of attorney's fees because it's been waived. But even if it had not been waived, for fees to be recoverable under Chapter 38, Casey must have recovered damages. Here, Casey made very clear in his response to Mira Skandari's motion to dismiss that he does not request damages. So you cannot get attorney's fees under Chapter 38, and that's the Green and International versus Solis case, the Texas Supreme Court. And then attorney's fees under Chapter 37 are not appropriate. The Supreme Court says, quote, as a vehicle to obtain otherwise impermissible attorney's fees. And so his claim for declaratory relief is simply duplicative of his claim that Mira Skandari breached the settlement agreement. So Casey cannot use Chapter 37 as a backdoor method to recover fees when he's not entitled to it under Chapter 38. But even setting aside those facts, the evidence that Mr. Casey submitted is completely insufficient to raise a to establish as a matter of law the reasonableness of his requested fees. We asserted several objections to Mr. Hopkins' testimony on fees because it fails to support the conclusions as to the reasonableness of his fees. And even if the court was to overrule those objections, I myself have submitted a declaration that raises a genuine issue of material fact on the reasonableness of the fees.
I'm going to deny the summary judgment on attorney's fees. That'll need to be tried. And so, Mr. Hopkins, you're going to need to prepare an order on this, detailing my rulings, and you need to share it with Mr. Kassab. Make sure at the beginning of the order it says that this was heard on November 7th, 2022, and make sure that you get it to me by no later than this Friday. So actually no later than this Thursday afternoon.
Yes, Your Honor.
Okay. And e-file it as well as email it, but the beginning should say on November 7th, 2022. And this case will need to be reopened. I'm going to go ahead and set it for trial. I can't imagine there's a whole lot needs to be done because we're just basically trying attorney's fees on January 3rd. Okay.
Thank you, Your Honor.
Your Honor, can I get a ruling on the objections just so the record's clear?
Well, as the attorney's fees, I grant your objections.
As to the Jinsoon litigation, Mr. Casey referenced by incorporation all filings from that litigation into his summary judgment motion, which is just entirely improper. You got to file the pleadings with the motion itself. So I would just like an objection, a ruling on that objection, sustaining that, so that the court was, specific as to what it was considering when it granted summary judgment.
Mr. Hopkins.
I'm sorry. So you're seeking a ruling as to that the court cannot consider the pleadings from the other litigation?
That was not attached to your summary judgment motion.
Okay. So to the extent that, I guess if the case is reopened, Your Honor, then we're able simply then to file that evidence now so the court can consider it before.
And let me just say the basis of my ruling has nothing to do with that. I just don't think the brother's an affiliate. I mean, that's my ruling. He's a brother is not, it's just because you're related to someone doesn't make you an affiliate. So
So it should make no difference to sustain the objection then, Your Honor. I mean, if that's the basis of the ruling, it's just entirely improper for them to incorporate by reference pleadings from it, all of the pleadings from another litigation in a summary judgment motion. And we cited case law that says
that particular objection, that very limited objection, is granted.
Thank you, Your Honor. That's all that I had other than the attorney's fee ones.
All right, Mr. Hopkins, go ahead and prepare that as part of the order as well. Share it with Mr. Kassab, try to get me an agreed as the form order and get it to me by Friday morning, okay?
Thank you, Your Honor.
Or Thursday afternoon. All right, guys, you have a great rest of your day.
You as
Thank
well.
you, Your Honor.
Thank you. I think we have one more motion or one more hearing.
Okay.
Let me see if that other hearing was canceled. We have a 4 o'clock. Yeah, I don't know what's going on.
Is it raining on your side of town?
A little bit, yeah, it's been raining on and off.
I went home for lunch,
Oh.
man, it was pouring, raining buckets out there.
Actually, this last hearing has been, the case has been stayed. So it's a little bit different than what we usually see. So we are done for today. So I will see you in the morning.
Yes, you will. Have a good evening.
Hope you feel better, Tony.
Thanks, Judge.
All
Bye-bye.
right, bye-bye.